Good afternoon. I call to order the GCC Special Board Meeting, December the 9th, 2025, at 1:45 p.m. Call to order, roll call. Mr. Mark Anderson?
Here.
Mr. Harry Block?
Here.
Mr. Bruce Mandrake?
Present.
Mr. Jack Turner?
Present.
Lily Campbell, present. All board members present and accounted. Do we have public comments today?
We have no public comments.
Superintendent's update. Superintendent, do you have an update at this point?
Madam President, there's no update.
All right. Well, at this point, we shall move right into item 4, study session. Ethnic and Brown Act training for Board of Directors and Cabinet, I believe.
Yes.
Yes. So we are here. Would you please introduce yourself and let us know who you are and what's expected of us today? Thank you so much for being here.
Absolutely. Thank you so much, Madam Chair. My name is Jerry Simmons. I'm one of the partners at Young Indian Corps, and we have represented you all since the beginning. I was actually the person who wrote your first charters that were approved by Grant High School District back in the day when Bruce was Chief Business Officer or some fancy title like that. And yeah, so anyway, so wonderful to be here to do your ethics training. So much has been accomplished in all those years by you all, and so it's a great privilege to be here with you. The legislature and their divine wisdom thought it was important that all of you receive a minimum 2 hours of ethics training every 2 years. So this is designed to satisfy that requirement, which you have to complete by January 1 of 2026. Once you complete this, then you have a 2-year grace. Also, recently, the legislature, also in their wisdom, thought it would be great for you to have fiscal training. So that will be coming soon to a boardroom near you. But you know, a lot of this stems from, and we'll talk about this, stems from bad actors elsewhere in the charter school movement, and the headlines they've generated. The audit reports they've generated have led the legislature to feel like we have to do something. And so their proposed solution was train everyone. I'm not convinced that the training is going to fix the problem of intentional bad actors, because you know, that's really a different sort of person altogether, right? But maybe at the margins it makes a difference with people who just didn't know and they make a misstep on one of the laws we're going to talk about today just simply because they didn't know better, right? So so maybe at the margins it makes a difference with regard to those folks, but you know, we're here today to do the training for you, to meet the obligation, and obviously it's become a more and more serious thing to sit on a charter school board. You know, back when I got started, you know, it was basically like going to a PTA meeting, you know, like who's going to bring the popcorn to the next one, you know, whatever. And now it's become a serious, you know, charter schools have become a serious enterprise. Some of whom, including you all, have really significant budgets that you manage and hundreds of employees that you manage and thousands of students that you serve. And so as a result, you are, you know, you're a very important part of how the state is serving the public, particularly in the education space. So without further ado, I'm just going to really advance us into the presentation. This is all the things this course has to cover in order to meet the legal requirement, and so we're going to talk about all those things, I promise. Great that you have, obviously, Jason and the cabinet here today. One of the things that the legislature did this last session is apply all of these same training requirements to the chief administrator of a charter school. In this case, Jason Sample, who is your superintendent and CEO, is who occupies that role for you. But wonderful to have other folks in the cabinet be trained as well, because as long as you're going to do it, the reality is a lot of the mistakes or lack of knowledge issues that come up are actually typically from people lower in the chart who don't receive the training as a matter of course, whereas typically your CEO and the board are trained, just as a matter of course. So this is just a little bit more about that training requirement for administrators, okay? Your current requirement is that you're going to maintain records of this for 5 years, documenting your compliance. So you'll hold on to these slides and somewhere in your files to prove, like I was here and did this training for you. And then effective July 1, charter schools with websites have to post instructions and contact information for the purpose of requesting records regarding compliance. So this is just one more of these has to be on your website somewhere kinds of things. So maybe think about putting that somewhere in the board section of your website. As I sort of previewed for you, coming up next, not part of this training, but coming up next will be fiscal training for charter school boards. This will be for folks who are in service as of April 1 of 2027. So it's not something you'll be doing next year, but about a year and a half from now, look for some fiscal training coming to a boardroom near you. You'll be pleased to note that although the legislature provided no minimum training time, they did at least cap it at 4 hours.
Oh.
So, and that training is going to include a lot of issues about, all the laws and regulations that pertain to creation and approval of budgets, fiscal penalties for non-compliance, and things like that. So with that sort of preview about what's coming next in the big picture, I want to talk now about ethics and sort of why we're here. Now, in this case, in this context, because the legislature had basically set the curriculum for today, it's not about the sort of dilemma you see on the screen where you're trying to decide, do I save the one person or the 5 people, because no matter which way I send the somebody is not going to end up doing well here, right? Like that's not what we're talking about. What we're talking about in this context is really all about just securing public trust, right? Through doing your work in a way that ensures that the public has a high degree of trust and confidence in all the decisions that you're making on their behalf, that you're spending money in ways that make sense and improve student outcomes, that you're treating folks with fairness in process, right? So in terms of why, why is it the legislature reacted? I mentioned to you that there were a number of other school district and charter school issues going on around California. I pulled a random sample of headlines, right? And so you'll see some of them here. You'll see some more here. It just goes on, really. I mean, and this is only a very small fraction of the headlines going on around the state of California, just even over the last few years. So if I had pulled all of these, we literally could have probably had 100 slides of nothing but headlines, just to give you a sense of how many issues there are in this space of conflict of interest law violations, people trying to profit off the backs of students in inappropriate ways, in extreme ways. So that's why the legislature thought, we're just going to apply this training requirement broadly, and we're going to try and just see if we can use that as a tool to get people to do better if they know better, right, is the theory here. So it's all about trustworthiness, right, which is a cycle, because trustworthiness comes because you treat people fairly, because you avoid the appearance of impropriety in all of the activities of the organization, because you take responsibility when there's errors, you acknowledge those and you fix them, as opposed to trying to bury them under a rug somewhere and pretending they didn't happen. Treating other people with respect, right? All of those things lead to the agency being trustworthy in its operations. So here's the core topics we're going to be talking about today. We're going to be talking about personal financial gain and when that is improper in this setting. We're going to talk about transparency laws, and of course, you're familiar with these. This is the open meeting law, right? This is the Public Records Act requirements, okay? So you're familiar, and I know have done some training on some of these topics for years. Fair processes, and this is really just about, when people file a complaint with you, that they're provided due process, that they're given an opportunity to be heard, that you also hear from the party that's being complained about, that you give them fair opportunity to be heard as well before you make decisions. Another category is use of public funds. So we're going to talk about, what are some areas where other charter schools around California have ended up in trouble over how they've used public funds and been called out in some way. So we're going to have some examples of that and how you can avoid those kinds of issues. And then we're going to have a category around bribery and gifts. I would say that this historically was not a big deal, because historically charter schools were really small entities and they had maybe a couple hundred students they served. So nobody would think to go bribe a charter school board member, because there would be no point, right? Like there wasn't enough money in it to make it worthwhile to do. But now that you see charter networks have formed, that people have a budget of 100 million or more, suddenly, you as charter school board members become potential targets of efforts to, obtain contracts or for services or for goods, and people may have more of an interest in you than they would have 20 years ago. Really in California, there's a web of state and federal laws that guide your service to the community here. And all of these laws just set minimum standards. So you as a board, you can always set a higher standard. If you feel like that standard isn't good enough as we go through the presentation today, you can always set a higher or better standard. You just can't ever go less than the standards we're going to talk about today. One of the other key concepts is that public service is about just that, service. And where a ton of charter schools have gone wrong over the years is you get a board member on a board and they view it as a money-making opportunity as opposed to a way to serve the community, right? And that orientation or that paradigm then leads them on a path to the dark side because they begin to make a series of decisions that lead them to violate a lot of the laws we're going to talk about today on their path to trying to use the charter school as a money-making venture as opposed to a community service donation of time, okay? So obviously, here in the context of a democracy also, it's important to know that leaders here, we don't have any special privileges, right? You don't have special privileges as a board member. I don't have a special privilege as a government agency lawyer. Jason doesn't have any special privileges as CEO here. In fact, if anything, we're more regulated, right, than the average member of the public is. But all of that is about, the concept here is just, look, unlike some of the European countries that have monarchies and things like that, where people have special privileges just because of their birth or their title or whatever, we don't have that here, right? So here, it's all about allowing members of the public and the media to understand what we're doing, the decisions we're making, why we're making those decisions, so that we can show that we are good stewards of the dollars that have been entrusted to us, of the resources and time that's been entrusted to us. And what happens if we breach those duties, right? Well, now, in light of the revisions the legislature approved to the Charter Schools Act, where there are either substantial fiscal or governance factors, a charter school can be denied renewal, even if it is so high performing that it's outperforming all of the public schools that those students would otherwise attend. So this set of issues has really been elevated in a new way since the passage of AB 1505, because doing extremely well serving students is not good enough anymore to sort of ignore breaches of the statutes we're going to talk about. The chartering authority can also revoke a charter where it has evidence that you've committed some violation of the charter, or you have failed to meet GAAP, or generally accepted accounting principles, or you've engaged in fiscal mismanagement, or you violated any law. Now, you have an opportunity to try to cure these sorts of violations before a revocation occurs. So there's a process that a chartering authority has to go through. However, I would say more and more we're seeing issues where districts are taking up notice and commencing a revocation process. I would say we've had more, probably in 2025, more notices than maybe, I would guess, at least the last 10 years combined. So it gives you a sense that there really is this ramping up by chartering authorities of a lot more oversight, a lot more notices, a lot more, engagement, and a lot less trust that, hey, I'm sure you're doing great over there. I saw the student test scores last week. There's just a lot less trust that the student test scores are enough. What are some other serious consequences? Well, if you have an ethical lapse, you could face removal as a board member. I just had this happen this year with a client where their board colleagues voted to remove them from the board. And it's a painful process because it occurs in open session. And so you can imagine having the board in open session discuss whether you should or shouldn't be removed from the board. It's embarrassing when that happens. So, but that is one of the potential options a board has if it finds that a colleague is not behaving according to norms that you've set. You could face a loss of employment, right? And how this comes up is, your boss reads about what's happening over there at that charter school whose board you sit on, and they think, I'm not sure I want to be affiliated with you anymore, right? Because maybe I feel like that damages my brand over here, right, where you're working and on your day job. So it can have implications like that, and I've seen that happen over the years. You could face criminal investigations, prosecution, jail time, financial penalties, and yes, all of those things have happened to charter school board members and administrators over the years. And I would say right now we have more criminal investigations going on of charter schools over the last 12 to 24 months than we've had in all of the prior years since the Charter Schools Act passed in 1992.
Are you going to talk about what some of those infractions might have been?
Yep, we're going to talk about several of those today. Yeah, exactly. It's my goal to not have you be in a situation like that, obviously. That's the whole point of the training, is to give you hopefully some practical pro tips. Do this, don't do this, so that you can avoid finding yourself in a scenario like that. Exactly. Administrative investigations, financial penalties. This can be, for example, the Fair Political Practices Commission has authority to do enforcement of the Form 700 requirements and things like that, and they can fine you if you don't have a form turned in on time, things like that. You can face civil litigation, where this often comes up is you let an employee go and they know you didn't do something right, and that becomes their opportunity to raise that issue publicly in litigation against you, claiming you retaliated against them for them having raised a legitimate compliance concern or something like that. And then reputational harm, and this is a huge one that I think a lot of folks just don't think about at the outset, But when you are in the newspaper for, breaches of ethical, duties, one of the things that often comes up is you have trouble recruiting good employees, because guess what everyone's going to do before they apply for a job with you? They're going to Google, and they're going to be like, Gateway Community Church. They're just going to see what Google pops up, right? And if the first 3 articles are things about board members engaging in bad conduct or administrators engaging in bad conduct, it may change whether they decide to even apply for the job, right? It may scare away good, really talented people, right? And the other thing it may do is it may scare away students, because they may think, gosh, I don't even know, this school might be revoked. So I don't know that I'm going to go sign up there. And so oftentimes what you see is schools that end up in the news, you see a cycle where their enrollment begins spinning downward, and where that then creates financial problems, which then creates other problems, right? So you can see that these things are interrelated, and they can create problems for you in unexpected ways sometimes. Here's our training roadmap. Those are the major categories we talked about on the left. And then, so we're going to spend a good deal of time on those first 2 categories, less on the remaining 3, really sort of proportional to have been with other schools. So first up, we have the open meeting law. So some of this will be a refresher to you, but there were some changes that went through this year, so I'm going to highlight those as well. So we're going to talk about the Brown Act in terms of these 6 questions. What's the purpose? What's a meeting? What are the notice and agenda requirements? What are the public's rights? What are permissible closed session topics? And what are penalties and remedies? Okay. There's some fancy language in the Brown Act that looks like it was written by a founding father, about the people not yielding their sovereignty to the agencies that serve them. It always makes me chuckle when I read that section of the Brown Act, but, really the goal is to foster broad public access, right? That's really the goal, and that's sort of the modern day translation, right? So the idea is that members of the public should have the ability to come to hear your discussions and your votes, to hear presentations, even like the one I'm doing now. Why? Because a presentation at one board meeting could lead to action 2 or 3 meetings down the road, right? It may be informing your thinking that leads you in a certain direction, okay? So how does the Brown Act accomplish that purpose of broad public access? First, by obviously giving notice to members of the public through your agenda posting on your website and your physical posting, okay? The idea behind this is that all of us have a dozen or more, probably, public agencies that serve us at any given time, and we can't be in a situation where we literally are attending all those agencies meetings every time they meet, just to find out if there's something that might impact us or our family, right? That would be a very inefficient way to do things. So the notice is designed to really allow people to know when is that one time that there's something on the agenda that is important enough for me that I'm going to arrange childcare, or I'm going to arrange time off my job so that I can go attend that meeting and give my input, which is pretty rare if you think about it. For most citizens, most of us, if we're just living our daily lives and we're not elected officials or appointed officials, for most of us, that might be once a decade, right? And it might only be one agency where we would show up that once a decade. So the idea of the agenda is really, in some ways, also to let members of the public know when they don't need to go as much as when they need to go, right? The meetings have to be open to the public, with the exception of your closed session portions of your meeting, of course. Transparency doesn't mean chaos, right? This is still your board meeting. You're doing your meeting in public, right? This is not like an East Coast town hall where everyone has the same opportunity to speak and you can speak over one another and things like that. That's not how things work here, right? This is your meeting. Your board chair, has the right to conduct the meeting, to remind people their time to speak is expired and move on to the next speaker, that sort of thing, because it's your meeting and you have the right to get through your agenda. And you've got a lot of things on your agenda. You have the right to get through those items, okay? You can always set more stringent requirements that foster greater access and participation. So we have some clients who say we're going to post our agendas a week in advance, not 72 hours. Or we're going to post the whole agenda packet online, not just the agenda. Or we're going to post the minutes online, not just the agenda, So those are all things that you can decide to do as a board that foster greater public access, but you could just never do less, right, than what we're going to talk about today. So what is a meeting? Okay, obviously, what's going to trigger that agenda posting requirement is any time that a majority of the board hears, discusses, deliberates, or takes action on an item of school business. Even just hearing a presentation like you're doing right now triggers an agenda posting requirement because you're hearing about an item that relates to the school in some fashion, right? So the most common violation of the Brown Act is where people say, well, Jerry, we didn't take any action. And I go, well, that wasn't necessary. Just hearing or discussing is sufficient if a majority of you were present to have created an agenda posting requirement, right? So what are some exceptions, though, to the definition of a meeting? You can attend a public conference of general interest. So for you, that might most typically be one of the 2 statewide charter school association conferences, for example. But it could be other things. There could be other education conferences that might be relevant. Attendance of a majority of you at some other public agency's public meeting. Now, where that would normally come up for a charter school is when one of your charter petitions comes up for renewal, or when, you've got a situation where a granting agency is noticing you of its intent to revoke a charter. If you ended up in either of those 2 scenarios. The next most common thing might be appearing at a city or county board of supervisors relating to some sort of facilities, issue, like you're needing to get a conditional use permit approved or something like that so that you can occupy a new facility. So those might be opportunities where a majority of you might be there. Why is that not a problem? Because they've posted an agenda and they've told members of the public, hey, we're considering the approval of GCC's facility at 123 Main Street, and granting a conditional use permit for them to be there. So they've put the public on notice. So the public already knows if they're concerned about that issue, they can go to the city council meeting that night and they can hear about that and they can weigh in, right? So the fact that a majority of you happen to also be there doesn't require us to do another notice. It's like, well, no, the public's already on notice, okay? Attendance of a majority at a purely social or ceremonial gathering. Now, this happens all the time this time of year, right? Holiday parties. If you sit on a board long enough, you're probably going to become friends with your board colleagues, and you might invite them to your Christmas party. You might also see them, obviously, at graduation, because this is a school, so that's a very common ceremonial activity for a school. And no problem, you can all be there, and you can all sit next to each other in the front row of the graduation ceremony. There's no problem with that, so long as you don't talk about school business. Now, that caveat applies to all 3 of these, right? So one time I had a situation where, unfortunately, a student had passed away, and the board showed up because it was a small school community. No problem that they were at the funeral. The problem was when they were at the back of the room talking about whether to expel a student or not. And then they got overheard talking about that at the back of the room at the funeral. And then that created a Brown Act problem for us just because they talked about school business while they were there. They could have all been there. That wasn't the problem, right? So just be mindful if you're in one of those locations, don't talk about school business while you're there, right? Now, committees. As a general rule, all committees are going to have to follow the Brown Act. There's one very, very, very narrow exception, right, that we're going to talk about. But as a general rule, committees, whether they're permanent or temporary, whether they're decision-making or advisory, and whether they're created by the charter document itself or some sort of ordinance or resolution or board action, they're going to be covered, okay? A standing committee also has to comply with the Brown Act, even if it's an advisory committee. So you have to be mindful of standing committees as well, generally being covered. And so those, you'll see what is a standing committee there on the right-hand side of the slide is your definition. You can refer back to these definitions later. But What are non-Brown Act committees? Well, there is an exception. If it's an advisory committee and it's composed solely of members of the board, it's less than a quorum of the board, and it is not a standing committee. If it meets all four of those, that's the one very, very narrow exception where that committee does not need to post an agenda. Now, what I can tell you in practice is that when people try to take advantage of this, oftentimes where they mess up is that they include non-board members on the committee itself. And they do that because they feel like, well, we need input from students, or we need input from parents, or we need input. That's fine, but now don't try and call it a non-Brown Act committee. You're going to need to post an agenda, right? So I always think about it this way. I always turn it around on the client, and I always say, well, what is it you need to accomplish? And whose input do you need? And if you need the input of those other stakeholder groups, by all means, put them on the committee. You just need to post the agenda, right? So, yeah, Mark.
The advisory board that are non-voting members, is that considered to be a standing committee?
So if you have, now, are we talking about a committee that has no board members at all, or that has a mix?
No, it's an advisory board. In other words, these are people that come together, think about new plans or ideas, or they're giving input, but they're not voting members, they're not voting board members, they're just an advisory board.
So they're an advisory board, and they give advice to who?
To the board.
To the board. Then yes, that kind of a committee, if they're giving advice to the board about matters of school business, is going to be subject to the Brown Act. So you want to think about one way that some schools, and the reason I asked you advisory to who, is because some schools have advisory committees that are advisory to the administration. And that can be different, right? And so you have to think about who are they advising, right? May make a difference in the answer. Yeah, Jack.
If you have an executive committee of, let's say, 2 board members that is advising the superintendent, does that, as a standing committee, do you need to have that to be posted? And it only has 2 board members, it's not a majority.
Because it's a standing committee, yes, it should be posted. And the reason why is because if you go back here, a standing committee has to comply with the Brown Act, even if it's just an advisory committee, even if it's composed solely of members of the board who are less than a quorum. So even though it's less than a quorum, even though it's just board members, even though it's just advisory, if it's a standing committee, then by nature of it being a standing committee, the Brown Act requirements apply. Now, it's a standing committee if it has some continuing subject matter jurisdiction, or if it has a meeting schedule fixed by the charter or the board's formal action, okay? And so executive committees, we have many clients who have executive committees. They post their agendas. That's perfectly fine. Again, no problem with executive committees. Now, one thing about executive committees that sometimes leads to, which is not about the Brown Act compliance to be clear, but just an additional pro tip for you, is that you should define what that committee's role is. In other words, is it truly just giving advice and the CEO can do something different? Or is it providing direction to the CEO in between board meetings? And I have some clients who have executive committees in both of those kinds of camps, right? And so it's important to just define that so everyone has a common understanding what that committee is going to do.
Okay, a follow-up question. If you post an agenda, do you have to televise the meeting like we're doing today?
So if you operate charter schools in more than one county, there is a requirement for you to video and audio record those meetings. If all of the board members are physically present here, right, then there is not going to be a projection requirement, right, as there would be if one of you was somewhere else. But if one of you is at some other location, you'll see that I'm going to come to a set of rules around that in a few minutes. And that will be an exception to this general notion. So yes, record, but not necessarily broadcast.
Okay, so let me summarize that. If you have a standing executive committee, you posted the agenda, you need to record the meeting, but you don't necessarily need, it doesn't have a quorum, you don't need to broadcast it.
So, okay, so now you've layered on another piece here, so let me just make sure that I go back a step, okay? You almost got it right. Let me just make sure that I summarize for you. There's a slightly different rule for the full board than for a committee, okay? So for the full board is going to record, okay, both audio and visual, but is not required to broadcast that unless one of the board members is somewhere other than where you all, the rest of the board is. In other words, where we've got a teleconference scenario going on. In the case of the executive committee, okay, or some other standing committee, they are not the legislative body of the agency, okay? So in that case, that committee is going to post the agenda. That's going to be its requirement, post the agenda, unless one of its members is participating from somewhere else other than the physical location where the remaining executive committee members have gathered.
Well, I am confused now. Let's just come back to the meeting we're having today. All the board members are here.
Correct.
Do we need to broadcast this meeting today?
You do not need to broadcast. You simply need to audio and visual record it.
So in the future, our board meetings, we do not need to broadcast them.
Correct.
If all the board members are present.
Correct.
Thank you.
I want to talk a little bit more about the executive committee
Yes.
and the function. There are two, and I guess I'm going to try to relate it to what we do, if that's appropriate.
Yes.
When we meet to talk about the board agenda that's coming up, two of us meet with the staff, the superintendent, the administrative assistant. And do we need to do anything differently than just have our meeting, set the agenda for coming up, and get it ready for posting and all of that?
The executive committee just needs to post its agenda and needs to describe what it's going to be talking about. So on that agenda might be something like agenda setting for the board meeting. Okay?
So no recording and no,
Not for the committee, no. Jack, I'm going to come back to you with one more little caveat added on to the answer to your piece, which is that each of your school resource centers, okay, and sites is designated under the law a teleconference location. Members of the public have the right to go to any of those school sites or resource centers and participate in your meeting from those locations. There is a requirement to broadcast to those locations, but there is not a requirement that you provide a general Zoom link to the whole world.
So it's just a specific.
So it's just to the sites and the resource centers. And the reason I want to offer that is because we have some clients who have said, Jerry, it's just too much trouble for us to figure out a direct link. The technology to create a direct link to 40 locations that we operate is just too much money. It's too complicated. We don't have the IT staff for that. It's easier for us just to use Zoom. Can we do that? Sure, you can use Zoom. And as long as you're doing the Zoom, can we just put that on the board agenda? Sure, if you want to. And that's an example where you might be providing greater public access, because now you're not just providing that direct access to each resource center and site location, but you're providing it wherever that person, wherever that stakeholder may be working or living. Does that clarification help? That may be why you may be doing something a little more.
Okay, can I follow up again just to summarize what I thought you said about a standing committee A standing committee needs to post. A standing committee needs to record.
A standing committee does not need to record, just needs to post, invite people to its meeting.
Oh, and invite people to the meeting.
Well, because it's an agendized, they posted the agenda, and so members of the public have the right to come.
So, Jerry, here's just, this is.
This is just kind of a follow-up with a standing board meeting. So, for instance, if I can't attend physically at the board meeting, but I want to participate, I think we have something on our books that we allow that twice in a fiscal year. Is that right, Jason?
I believe so. This is for emergency reasons.
For emergency reasons, yeah. We'll come to some special rules on that,
Okay,
which
fine.
actually just changed again for January 1.
Okay.
So,
There's some changes.
Okay, so
that's
I
one
don't
of
want
the
to
areas-
belabor it. It's just something, it's happened to me where I can't attend
Yes.
either, but I want to participate.
And I'm
want
going to give you
clarity on
options.
it.
I'm going to give you options. It is allowed, and I'm going to give you some options on how. And so, and there's some which don't require any special findings, I'm going to say, special circumstances, and there's some that require special circumstances, but the rules are a little different. And so we're going to go over both paths in a few minutes. Yep. All right, so serial meetings are prohibited. This is anytime, it's basically the exact opposite of what you're supposed to do, right? This is where a majority of you, outside of a meeting where you've posted an agenda, use a series of communications of any kind, whether it's directly or through an intermediary. Who is that, right? Well, Bruce knows he can't call a majority of the trustees, so he's like, hey, you're my brother. Can you go and carry the following message to Lily and Harry and Mark and Jack? Here's the message, Okay, that's improper. Now he's turned his brother into an intermediary. It's essentially someone who is going to deliver exactly the message that he is personally prohibited from delivering. You can't do that, right? Because that would defeat the whole purpose of the law if somebody could send their spouse or send their brother to deliver the exact message they can't deliver themselves. Right, so you can't use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of charter school business, right? So this is, again, exactly the opposite of what you're supposed to be doing. Where should you be having those communications? At a board meeting. If you have things you want to talk about with your board colleagues, by all means, do it at a board meeting, right? One other sort of limit that kind of often comes up, and this actually applies to Jason and the cabinet and other staff of the school. You might have questions that come up as you read your agenda packet, and you might, for example, be like, well, gosh, I don't really understand this budget line item. Why did this go up 30% versus last year? And you might think, well, I want to reach out and call the fiscal person and ask, why is there such a big discrepancy from last year to this year before I vote to approve the budget, right? That's perfectly okay for you to do that. In fact, it's wonderful because, one, it may be that you caught a mistake, right? And it's great to correct that. Two, it could be that there's some good reason and you need to understand what that good reason is, why there's a change of that significance, right? And the staff can answer all those questions for you outside of a meeting. That's fine. And they can do that even if all 5 of you, separately and individually, had that same question after you read the agenda packet. The only thing the chief business officer can't do is they can't say during that conversation, I know Bruce shares your concern and wants to make a change on that also. That sharing of another board member's comment or position on that same issue is prohibited. Staff cannot share that. They can answer your question, and they can do that 5 separate times and 5 separate calls or 5 separate emails, perfectly fine, but the staff just can't share where any other board member sits on that issue. And the reason why is because obviously if we allowed that sort of sharing, it would facilitate the whole board coming to agreement outside of a meeting. And we don't want that. We want you to come to that agreement to make a change at a board meeting where members of the public are here and they're able to hear the question, they're able to hear, oh, that was a mistake, or here's why, or whatever, and that whole conversation occurs here at a board meeting with all 5 of you present, where members of the public can hear that conversation in real time. Okay, so that's the theory behind why that's the case. Now we're going to get to this question of the resource, of these teleconference locations, right? So in your case, you are in this last category. You're an entity that manages 2 or more charter schools that are not located in the same county, which means you always have to meet within the physical boundaries of the county in which the greatest number of students enrolled in those schools reside. So it's a residency of students requirement. That's what it's tied to, okay? Not which school they attend. And we've had some charter networks get in trouble over that because the residency was different than the school of the county that they actually attended. So for example, you might have 500 students who live in Yolo County but who drive over the bridge and attend school here in Sacramento. They don't count as Sacramento County for this purpose because their residency is Yolo County. That's sort of the trick here, right? A 2-way teleconference is present at each school site and resource center, right, as we discussed. And you have to audio and video record or both the governing board meetings and post the recordings on each charter school's internet website. So there is that posting requirement following the recording taking place, okay? So, and again, as I said, a lot of charter networks handle this by also just providing a Zoom link for members of the public because that's easier for them to manage than managing the technology of a closed circuit link with all of the resource centers, especially as you get bigger, that just becomes harder and harder and more costly. So now we're going to get, Mark, to your question about remote participation in meetings by board members and the different ways that that can occur. So by far the easiest way is this way. So this has been in the Brown Act for years and years and years. I mean, it goes all the way back, right? Even when, when we were doing this work 20-something years ago, this was in the Brown Act then too. All votes have to be taken by roll call. So what that means is that your staff or the board chair will call each board member's name and wait for them to say yes, no, or abstain, right? The agenda has to be posted at all teleconference locations. So what that means is that if you're going to call from the Hilton in Milwaukee, that's fine, but you're going to have what? An agenda posted at the Hilton in Milwaukee, okay? And it has to be identified in the notice and agenda of the meeting. So that address of the Hilton in Milwaukee has to be there in addition to this address on Arnold Avenue at the top of the agenda, okay? Now, also, members of the public have the right to address the board directly at each teleconference location. So if a member of the public happened to be in Milwaukee and thought, this is convenient, I'm also at this business conference in Milwaukee, I'm just going to go to Mark's room and I'll participate in the GCC board meeting from there. They would have every right to do that. So just know that that's a theoretical possibility. Obviously, the further you are away from Sacramento, the less likely you're going to have a random member of the public showing up at your room to participate in the meeting, but it could happen. When does this happen? I will tell you it happens when I've seen it occur, at least in the past, it has happened where someone's home or office is more convenient to them than the board meeting site. And they think, that board meeting is occurring right around rush hour. I'd rather go to Mark's office in Elk Grove, because I live in Elk Grove, than drive all the way to Arnold Avenue in rush hour, because that means I would have to take a lot of time off work to be able to be there on time, right? And so I had this happen, for example, to one of my board members at another school who was at home and recovering from a cancer surgery. And for years, the school had had no one attend any of their meetings. I mean, literally no member of the public attended their meetings for years. Of course, at this meeting, this was the meeting where something controversial arose, and no one even knew it was going to be a controversial meeting, but it involved a personnel matter that happened after the agenda was posted. And it created a flurry of activity because parents were mad, and they were going to be heard, and they were going to be heard at this meeting, and so they decided to show up. And where'd they show up? At the board member's house, because if they had gone on to the meeting location, it was another 45 minutes on a windy mountain road in the rain. So they thought, well, we're just all going to stop at the board member's house. That's convenient. Not realizing she was recovering from cancer and all of this. And so, of course, this created quite a mess because, she wasn't prepared to receive people. She was in her pajamas, and, it was just, it was quite a nightmare scenario, right? But, so just keep in mind, when you utilize this provision, that you have to be willing to let members of the public in, and so, in case, right, that somebody actually did show up. Yeah, Tech.
Jerry, is there a limit on the number of times you can use this?
There is no limit on the number of times you can use this particular, what I'm going to call Path 1, okay? This one you can use an unlimited number of times, okay? What we're going to talk about in a moment is Path 2, which relates to emergency or just cause participation in a meeting, and the rules for that do limit the number of times you can use it. And I think that was what Jason was referring to earlier, was someone wanting to use those rules to participate in a meeting.
Okay, but let me just kind of summarize this one. So a board member could use this unlimited number of times.
They could use it for
at
every
the
meeting.
remote site.
They could use it for every meeting at a remote site if they wanted to do so, as long as all these provisions were met.
As long as they had a majority of quorum at the site under jurisdiction. Okay.
That is
thank you.
correct. That is correct. Okay, so this is Path 1, right? So, and so a lot of flexibility in terms of numbers of times you can use it. It's just really that quorum in the school's jurisdiction and making sure the address is listed, making sure the agenda is really posted there, the whole posting period, all those pieces, right? But as long as you do these 6 things, yes, unlimited.
Jerry, and you can be a voting member being remote.
You absolutely can, yes, you're a voting member.
Okay.
Now, in fact, I'm going to tell you something else, right, that relates to that, because what do people sometimes try to do that is a problem? They're running late to the meeting, they're on the I-5 freeway, and they want to call into the meeting on their drive there. Now, here's the problem. Did we post the agenda on your car window 72 hours ago? Did we, what's the location? I'm supposed to parachute in like Captain America into your car, on the I-5. I'm supposed to magically know where you are and drop from the plane into your passenger seat. Like, it doesn't work, right? So the one issue we have with board members voting is when these rules haven't been followed, right? And somebody's trying to call in and still participate and still vote in the meeting. That's problematic. Okay. So, because we're now on December 9th, the reality is your next board meeting is going to apply under these new rules that were part of Senate Bill 707. These amendments become effective technically on January 1, 2026. Technically,
Board meeting this afternoon,
so this applies, yeah, not at the board meeting that we're at presently, but your next,
well, my next one is at 4:45 today.
oh, okay, but that's part of this. It's part of today.
Okay.
Yeah, but your next, I'm talking about.
Okay.
Your-
After.
yeah.
Yeah, January, okay.
Right, is going to occur in January, right?
Okay, yeah.
Because you're not going to want to meet by Christmas if you can possibly help it. So these will be the rules. So I just put these rules in because this is going to be what to think about, right? I don't want to confuse you by putting in rules that you're not actually going to use in the next 20 days, okay? So this one allows relaxed video conferencing requirements for members for what we call just cause. And previously, there was just cause and emergency, and there were 2 different reasons why you might qualify. The legislature has now said we're dropping that emergency word. All the things that were emergencies under the old rules are now part of just cause. We're going to call it all one thing, which thankfully is at least somewhat cleaner and clearer. It allows video conferencing without any obligation to identify the teleconferencing location on the agenda or to allow public access to the teleconferencing location. So those are the two reasons why somebody might want to utilize the just cause provisions instead of the first set of rules that we just talked about, right? Because if it's too late, if the agenda's already been posted and you realize 24 hours in advance, whoops, I'm not going to be able to be at the board meeting because I'm flying somewhere, my mom's sick and I need to fly to Arkansas, I'll be there. Well, okay, but the agenda's already posted, and guess what? It wasn't posted in Arkansas 72 hours in advance, and we didn't list the address in Arkansas 72 hours in advance, so I'm sorry your mom's sick, but we can't accommodate you under path 1. So we have to look here. Is there a reason how we could get you to qualify under path 2 for just cause, right? Now, there's a number of, in exchange for those 2 additional pieces of flexibility that might help you in a last minute scenario, there's a bunch of other rules that apply only here, right? So the first is the member has to participate through both audio and visual technology. So not just a telephone, that won't do. A speakerphone won't do. We've got to have a video link to you. It's also only allowable if a quorum of the remaining members participate in person from a single physical location, right? Now, that's probably not a problem for you because you traditionally do come together at a single physical location. But if you had a circumstance where you had multiple members, right, needing different things, this becomes a problem. So let's say that Bruce had notified Jason 72 hours in advance, I'm going to be at the Hilton in Milwaukee, Jason, so I need you to post, make sure that it gets posted there. I need that address listed on the agenda. That's where I'm going to call in from. Well, guess what? Now Mark, finds out his mom's sick last minute, 24 hours in advance, and is like, Jason, I need to, and he's going to say what? Well, let me count. I have to count. Bruce, that's okay, because that's only 1, so I've still got the remaining 3 here at a single physical location, so yes, Mark, we can accommodate you also. But if a third board member reaches out to Jason, that's when we're going to have a problem, because let's say Jack reaches out and says, I'm sick, I just can't make it to this meeting. Now we've only got 2. Now we don't have a quorum here physically. And therefore what? We can't grant Mark's request, to participate in the meeting under path 2 because we don't have a quorum here at a single physical location because Bruce had a pre-planned trip and we knew about it. And then Jack got sick, and so now we're down to 2. That's not a quorum here at a single physical location, right? So what would we do? We would have to deny Mark's request. Unfortunately, we said, we're sorry, we'll see you at the next meeting, but we can't accommodate that, right? And so we've got, that's why when you got a 5-member board, you have to do the math to see, does it work? If everyone else is going to be there, it's fine, but if we have different people needing different things, it's complicated, and staff has to sort of sort that out to figure out, can we make the math work, right, to allow someone to do a path 2. Some other things, right, just cause means the things on this list and nothing else, okay? So now there's a lot of things on this list, a child care or caregiving need of all of those different family members. Maybe you've got a contagious illness that prevents you from attending in person, which, by the way, is not just COVID, although that was its original context. It could be any sort of contagious illness will do. A need related to a physical or mental disability not otherwise accommodated. We had a circumstance like this where a board member had leg surgery and couldn't drive temporarily. And so we said, here, boom, need related to a physical disability not otherwise accommodated. Yes, we can accommodate you under path 2. We're going to count you. Travel while in official business, either of this school, right, or some other state or local agency. So maybe you're an employee of the state or you're an employee of a local agency. You're traveling as part of your day job for that. Maybe you're at the League of Cities conference because you're the assistant city manager. Not a problem. That will qualify you there. Travel for another local agency. You've got some immunocompromised family member that requires the member to participate remotely because we're concerned that you might be a conveyor of a disease to that immunocompromised person, okay? We've got a physical or family medical emergency, okay, that prevents a member from attending in person, or we've got a military service obligation. That's something new that got added as part of this. That was not part of the prior law at all. So that's a new thing. But if you hit one of those things, you've got just cause, okay? We talked about the meeting caps, and Jack, this comes back to the meeting caps. So under Path 2, there are meeting caps, and they're here on this slide, so you can refer to this. 2 meetings per year if you meet once a month or less. 5 meetings per year if you meet twice a month or more, right? 7 meetings per year if the body meets 3 times a month. So it really just depends how many meetings do you have as a board is going to set what your cap is. It'll either be 2, 5, or 7 depending on how many meetings you have per year as a board.
This gets back to the definition of an emergency for a family member. Assume you had a spouse who was just seriously ill or just ill. Would that be a definition for emergency?
Well, I think at very least it's going to be a caregiving need of a spouse. So I think it would fit just cause, because even if it wasn't a medical emergency, if the person is sufficiently sick that they require your care, it's a caregiving need under bullet 1 in my view.
Thank you.
Note that some of the language here is a little different than what it was before also, okay? So as the legislature merged these things, they also tweaked some of the language throughout. So this is an opportunity for you to sort of realign your policies and procedures to the new rules. Okay, other requirements. The board member has to notify the board, this is Path 2 only. The board member has to notify the board at the earliest opportunity possible, including at the start of a regular meeting, of their need to participate remotely for just cause, including a general description of the circumstances, in other words, the reasons why you need to appear remotely at that particular meeting. The meeting minutes now have to identify the members who participated remotely, the legal provision under which they're participating remotely, and the just cause reason for their participation. So we'd have to say the board member cited child caregiving need, or the member cited a family medical emergency, or we'd have to say in the minutes what that reason was. Okay, so this is Path 2. Those were not part of the prior, the meeting minutes piece was not part of the prior law, so that's a new thing also, right? Members of the public also have to be provided a means to remotely hear and visually observe the meeting and remotely address the governing board, right? Meaning there has to be a two-way audio-visual platform or a two-way telephonic service and live webcasting simultaneously, right? If you're not going to use something like Zoom that has both audio and visual built in. There are also requirements that you put on the agenda itself, notice for how the public can participate in your meeting, right? So if you ever intend to have or allow a board member to participate under Path 2, you would have to print on every single agenda the means by which the public can participate in your meeting. Otherwise, when someone calls you and says, I want to use Path 2, you're going to say, sorry, we can't because we didn't post language on every single agenda just in case someone might need to use it, okay? And then the member has to publicly disclose before any action is taken if anyone 18 years of age or older is present in the room and the general nature of your relationship with that person. Why? I have no idea why. It's stupid. It is the stupidest thing I've ever heard of. I don't know what ledge staffer at 2 in the morning thought this was a good idea. I mean, it's just like, why? If I'm in the hospital with my mom, I really have to tell you that this is my mom's nurse and her name's Julie, and that's the nature of my relationship, is she's my mom's nurse. Why does the public need to know this? I don't know, but it's part of the law. And what's frustrating is I could show up here at the meeting, I could sit in one of these chairs, and I don't have to tell you my name. I don't have to tell you why I'm here. I don't have to tell you anything, right? But if I happen to be in the room with a board member when one of you uses Path 2 for an audio, video, visual teleconference, you're going to have to tell who I am, what my name is, what the nature of your relationship with me is, And, I was imagining there might be some awkward circumstances, but so far there haven't been any awkward ones. It's just been medical things. It's just been weird, because it's like, who cares? All right, SB 707 did another thing. They created a Path 3 for the first time, right? Path 3 now is you've got some special rules for accommodating board members with disabilities. If you have a board member with a disability that precludes their attendance in person, they may be accommodated by allowing them to participate in the meeting remotely. And interestingly, disability-related remote participation counts toward physical quorum as though that person were in person at the physical meeting location. So they help you count toward quorum. Also, it has to be both audio and visual technology unless a physical condition necessitates off-camera participation. So it's a little bit of an awkward conversation now, like, what is your nature of your disability and why can you not use visual technology? I don't know. These are going to be awkward conversations, but it is part of the law here. So this is a Path 3 that can be utilized to allow a board member to participate audio visual. Okay? And if that person does that, then guess what? Just like the Path 2, you have to disclose if there's someone 18 years of age or older in the room with you and what the general nature of your relationship with them might be. So, okay. Path 4. Okay, is we also have authorization during a proclaimed state of emergency where the governing board, that's you, meets for the purpose of determining whether meeting in person would present imminent health risks, or you previously made that determination, and then you continue to make those findings every 45 days, that you have reconsidered the circumstances of the state of or local emergency, and that state or local emergency continues to directly impact the ability of you to meet safely in person. So obviously the intent of this originally was COVID, right? But it's been expanded a little bit now, and so because we did have a number of both school districts and charter schools who were impacted in the fires in LA, and previously both the school district and several charter schools in Paradise, California during the fires there. And so I think there was a recognition by many members of the legislature that, hey, there actually kind of is a need beyond just COVID for this. Like, there are circumstances where a state or local emergency, because of maybe excessive smoke or something else, maybe it's just not possible to meet in person within the jurisdiction. So local emergency is defined as a condition of extreme peril to persons or property proclaimed by the governing body of the local agency affected in accordance with the California Emergency Services Act. So what's interesting about this is that charter schools are not typically deemed a local agency for these kinds of purposes. So what we assume the interpretation ultimately is probably going to be is that the city or county has to declare that emergency in the area in which your schools are operating or located, and that their declaration of emergency would then be relied upon by you. That's how we think it will actually work probably in practice. Question here.
So we can't have any Zoom meeting?
So no fully virtual meetings like happened during COVID. Those are under none of the paths, except the state or local emergency path that we just talked about. Okay, so there'd have to be a proclaimed state of emergency for this area where you're physically located in order to trigger any ability to meet like that again. Okay, so what are these notice and agenda requirements? Well, you have to post that agenda, and it has to include a brief description of the items that are going to be transacted or discussed. With very few exceptions, if an item is not on the agenda, the board cannot discuss it. And of course, the whole point of that is because if you just told members of the public what you were going to be talking about, and if you talk about something else, well, they might have taken time off work or arranged childcare to be there if they had known you were going to talk about this other thing that you did not notice them about. However, there are some exceptions in the law. So I have them here for your bonus points, right, in case you ever really, truly need them. A majority of you could determine that an emergency or dire emergency exists that requires you to take action, okay? This is extremely rare. Picture and imagine that I'm going to be before a judge trying to defend you doing this, and the judge is going to say, how many people are going to die, Mr. Simmons, if the board didn't act? How many people are going to be seriously injured if the board didn't act? How was the roof really perilously on the brink of collapsing that very afternoon, Mr. Simmons? Like, I'm going to face a lot of hard questions to defend this, so make sure that it really is truly an emergency or dire emergency, and it truly, people's health and safety was somehow dramatically at risk, so much so that you couldn't call a special meeting 24 hours later. Like, it's got to be something that required that sort of immediacy of action in order to prevent the harm. Upon a determination by two-thirds vote of you, or unanimously if less than two-thirds of you are present, that there's a need to take immediate action and that the need for action came to the attention of the board after the agenda was posted. This also extremely rare, right? This is not to cover, just to be really clear, a circumstance where staff forgets to put something on the agenda that one of you asked to have placed on the agenda. It's not to cover a forgetfulness situation. It's to cover a situation that genuinely arose after that agenda got posted. Something changed, right? And now there's a need to take action. Or the agenda item was posted for a prior meeting of the board that occurred not more than 5 calendar days prior to the date action was taken on the action, and at that prior meeting you continued the item to the subsequent meeting within 5 days. Now, why would this one come up? This comes up, I'll tell you exactly the scenario where this comes up. Something controversial happens and you, the board, are so gracious because no one ever shows up really at your meetings, and suddenly you have 500 people there at your board meeting. You look out at the crowd, you're like, well, I'm not going to tell them they're not going to be able to speak for more than 20 minutes. I'm going to let them go. If they have 500 people really thought it was so important, I'm going to let them speak maybe, more than the limit, right? Maybe. And you're going to hear them out. And okay, so in that sort of circumstance, you've now heard from testimony from 50 people, let's say, out of those 500 who showed up. You were so gracious, you let every one of those 50 who turned in a card speak, okay? Well, you don't now want to hear from them again 3 days later when you take up the item to actually discuss and vote on it, right? Like, you don't want to hear from them again. So what are you going to do? You're going to continue the item so that you can pick up where that conversation left off directly with board discussion and vote, right? As opposed to having to reopen the whole thing again, okay? Now, direction to staff. This is just brief direction to staff. Like, somebody shows up during public comment and they've got a complaint and you say, Jason, could you look into this and report back? Or Jason, could you look into this and address that parent's concern? You know, it's just brief, very brief, one sentence kind of direction. The board can give that sort of direction to staff at a board meeting. You can also provide brief responses. You can ask clarifying questions. Like, a clarifying question often that comes up at our clients' meetings. What school is it that your child attends? Because you operate multiple schools, so it's important context for you to understand. I don't have context without you telling me at least what school your kid goes to. I can't really process, you know, what you're talking about, that the roof's going to cave in over there in the English classroom. I don't know what you mean until I find out where, right? Announcements would be something like, you know, graduation ceremony next Tuesday, 6 o'clock. Hope to see you all there, right? And then this last one, identification of future agenda items. This is not a substantive conversation about something. It is just simply, Madam Chair, it's apparent to me that we need to talk about some revisions to the budget that we approved. And so I'd like to ask that be on the agenda at the next meeting. Right? It's just asking, I'd like this on some future agenda. It's not a substantive conversation about why we need to change the budget or what we're going to change it to. It's just, I'm asking that this be scheduled, right? And then we can return to it.
Who's asking it? That can come from the board, or the board members, not someone in the audience.
Well, I mean, someone in the audience could, I suppose, ask during public comment, but you're not obligated to honor,
Okay.
you know, necessarily.
Okay,
But you may have a board member ask, and of course, you're probably going
yeah.
to be deferential to say, if somebody on the board feels we need to discuss that, well, we'll find a time, and we'll come back to it. It doesn't mean you're going to necessarily agree with that board member substantively when the vote comes up. It just means a request has been made to add it to a future agenda
Right.
item for
That will
conversation. And, now you're going to just, briefly hear that request, and now the request has been made, and you can make some determination as chair in concert with Jason when might that logically be heard. Is it at the next meeting or in 2 meetings? All those kinds of logistics happen behind the scenes, but it's just sort of an opportunity where, even though it's not on the agenda, someone can ask for something to be in a future meeting.
Okay.
Jack?
Jerry, in my prior life, I taught parliamentary law. Can I ask a question? Can I have an item tabled for a date definite, so like the next meeting? And then have that item, then it is a continuation of the meeting that we had the people speak at, but then we would not have to have an open hearing again at the next meeting?
It depends. Of course, you know that you're going to get that kind of answer from me as a lawyer, but it depends on a few factors. One is, obviously, it has to be within 5 days, that meeting. It can't be, 15 days later or 30 days later, right? So that probably is going to make a postponement to a future meeting not feasible unless you already had a special meeting scheduled, right, that was within the 5 days, or you convince your colleagues that, hey, I don't want to make this decision today because I have some good reason, staff needs to do more homework, whatever, so I want to come back, I want to call a special meeting within 5 days, and I'm going to try to lobby you all to get on the same page to meet again within 5 days so that we can continue this item, right? And then it's a continuation of the item that was originally on the agenda, not something new, and I say that because sometimes, then when staff goes and does the additional research that you ask them to do, maybe there's a different recommendation, maybe it needs to go in a different direction, and maybe that's not what you noticed the public you were planning to talk about at meeting number 1. So it has to truly be a continuation of this item that you noticed people about already, right? And so if there's some change, if all that public testimony caused you to think, well, maybe we need to go in a new direction, that's going to require a new agenda posting.
It's intriguing. Yes, I understand.
So it's very limited, but it's theoretically there in a very limited circumstance, right? So it's a possibility. All right, so what are these agenda posting requirements? Regular meetings are 72 hours in advance. Special meetings are 24 hours in advance. And I will tell you 99.9% of charter school meetings in California are one of those two things. There is one very small thing for an emergency meeting, which requires only an hour's notice, and it requires, a sort of not a normal natural disaster, but a sort of catastrophic natural disaster or work stoppage. You've got to have one of those two things. Work stoppage meaning like a strike, right? Now, most charter schools don't have unions, so strikes really aren't a thing for most charter schools, okay? So, but we did one time, probably 20 years ago, have a circumstance where at a particular charter school, teachers got mad about something, and they walked off the job and they sat in the public street in front of the school to stop traffic in all directions. And that constituted an emergency, right? And the charter school board was able to convene with that shorter notice period. But what I would say is, it's virtually never going to come up. So just be thinking in your mind, 24 hours at least, right, in virtually any circumstance. Oh, Jack, yeah.
And just another question. I've always been intrigued. The 72 hours, it makes no difference if it's over a holiday, a weekend, anything. It just has to be 72 hours.
Any 72 hours will do. Holidays count, weekends count. School closure still counts. Doesn't matter, as long as you got the 72 hours. Yep. All right, where are you going to post it? You're going to post it in a physical location where if somebody rode by on their bicycle at 2 in the morning, they could see the physical agenda posted somewhere. You're going to post it on the website. You're going to use a prominent direct link on the front page. And it has to be downloadable, it has to be searchable, it has to be free access, obviously. You're going to have that brief description that we talked about before. If you have a closed session at that particular meeting, you're going to use the safe harbor language. Now, the safe harbor language, there is a particular language for any reason a charter school can be in closed session. You literally cut and paste it right out of the statute and you fill in the blanks. So they've made it so simple. Just cut and paste and fill in the blanks. Also, then you have to provide verbal notice in advance of the closed session that you're going into closed session and why, which is just as simple as reading, what are the reasons that are printed on the agenda. And then following the closed session, you make a public report of any action that's taken in closed session, as well as a roll call vote of every member, right? So you would, again, read aloud, the following board members voting yes, the following board members voting no, the following board members abstaining. And that would be listed in the minutes as a record of that closed session roll call vote,
That is,
if action is taken.
if action is taken.
Yes.
But if no action is taken, we
Then no
come back
action
and
is
say no
taken.
action is taken, it's
Correct.
just a matter of information.
Correct.
Yeah.
Correct.
Okay.
And that often happens, because for example, with litigation, sometimes it goes on for 2-3 years, right? And there may be just updates provided to the board
Yeah.
in closed session, like, well, we're scheduled for hearing on such and such a date, we filed a brief on such and such a date, the other side's arguing this, just FYI, things like that. There may just be these updates, right, that occur, and there's no action
Right.
by the board, but we're providing you information, or someone else on one of the other appropriate items why you can be in closed session. It's just providing the board information.
But go back quickly to the action, if action is taken, you said a roll call vote is necessary. And then I'm reporting out, I have to say, board members
Who voted yes by name?
by name.
Who voted no
As
by
I'm
name?
reporting out.
Yeah, not just the vote was 3-2, or the vote was
Also,
5-0.
Okay,
Right, we want to know who specifically voted each way on all closed session
Okay.
items, and we want that recorded in the minutes.
okay.
And that's important for you all as board members too, because in the event, and I know it's rare, right, but in the event you ended up in a circumstance where maybe you got outvoted on something that was of consequence, you would want people to know how you cast your vote, because you probably cast your vote for a good reason, why you thought differently than your colleagues, and you just want to make sure that you have an opportunity to be heard in that respect, that you disagreed, right? And the same on the other side. If you cast a vote yes, you probably want people to know, here is where I stood on that
But
issue.
if all of us voted yes, then I have to say, Mark Anderson voted yes, Jack Turner voted yes, and all five, and
Yes.
name all five of us. who
Yes, and
voted
why would I
yes.
do that? Because sometimes board members leave. So if all you have is the minutes, and at the beginning of the meeting, all 5 of you were listed as present,
Yeah.
the assumption is all 5 of you voted yes in closed session at the end of the meeting, right? Unless, what? Unless the report out of closed session reflects there were only 4 yes votes, and then what that signals to the public is Bruce wasn't there, right? Bruce wasn't there for that vote. That's why it's 4-0 with the following people voting yes, not. And so what sometimes causes confusion is that charter school chairs will say something like, the vote was unanimous.
Yeah,
Well, the vote was unanimous is different because now I don't know that Bruce was absent. I might assume, because I read at the start of the meeting all 5 were present, I'm going to assume all 5 voted yes,
no.
right? And so that's just, that distinction can be helpful in that circumstance.
I usually do roll call vote for everything, just about, by name, yes. Now, when it's reported back in the minutes, Mark Anderson voted yes, Bruce Mandrick voted no, whatever. So that has to be recorded for all of the votes or not?
So for anything for which a roll call vote is required, I would record it in the minutes. Now, not everything requires a roll call vote, but for example, if someone's using teleconference procedures, a roll call vote is required. In which case, I think a roll call vote should be recorded in the minutes. And here, the closed session requirement is that you report out the roll call vote or abstention of every member. And so I think the expectation would be that the minutes would reflect a vote by member. Yeah, Bruce.
Closed session, there's always, in my mind, a question of what is action? If you direct the superintendent to do something that's not formal action, what is a formal action?
Yeah. Well, we don't have a ton of case law on this, which it's certainly a gray area, right? So usually my rule of thumb is to report something general if action was taken and it's a gray area. So for example, I would rather report out the board provided direction to legal counsel on a matter of anticipated litigation, period. Not the board directed Jerry to go offer $600,000 to the plaintiff in this case, right? We don't want to do that. So we don't want to over-disclose, right? But if there truly was direction given, you can say the board gave direction to legal counsel on a matter of anticipated litigation, period. The vote was 3-2, with the following board members voting yes, the following board members voting no, the following board members abstaining, right? That would be the report out. And then it's clear that something happened. There was some direction, right? But the members of the public aren't going to know the attorney-client privileged piece of what that instruction specifically was. But they'll know that there was some direction provided, right? And that can be important sometimes in signaling something to the other side, right? Because sometimes there might be a question, well, do I have authority to settle this? And I'll say, yes, the board gave me authority. Well, Jerry, I don't see anything in the minutes that says they ever took action. At what meeting did they take action to give you authority? Where at least if there's some general report out, the direction was given to the legal counsel on a matter of anticipated litigation, I can say, well, on December 10th, and you'll see in the report out of closed session, direction was provided to legal counsel on matter of anticipated litigation. That was what we're talking about right now. That's the direction I was provided. I was authorized to settle this with you for X. Does that make sense? It can be helpful in a circumstance like that where there's some question about, authority or something like that. But I wouldn't, you obviously also you want to preserve confidentiality, obviously, with regard to employment issues and student issues. You're never going to reveal people's names in a report out. So even if you say expel a student, you're never going to say that student's name, right? You're just going to say the board voted to expel a student. You're not going to reveal confidential stuff. Jack. Yeah.
Jack.
Madam President, can I have a point of personal privilege and request a break for about 3 minutes?
I think we can do that. We would ask the speaker if.
Of course.
At a point where you can.
Sure, absolutely.
Everyone come back, I want to talk about abstention. Just because you mentioned the word, so remind me.
Yes, okay, absolutely.
All right, we'll do 3 minutes. Those who need to take a break.
we ready to go? Okay, you said you wanted to come back, Madam Chair, to a question about abstentions that you had.
When someone like stays, is that the same as a no vote?
Not necessarily.
Not necessarily, okay.
And so it's going to depend, right, on whether it is something that requires a certain percentage of yes votes, in which case it may have the effect of a no vote, only in the sense that it's not a yes, right? So, for example, when I said that under that one provision of the Brown Act, it requires a 2/3 vote, well, 2/3 vote of 5, right? And so if someone is not voting yes, it's basically the same as a no. It counts essentially the same as a no because it's not a yes. They're not helping you to get to the 2/3 yes that is required, right? So there can be circumstances like that. Similarly, if there is a majority vote, right, and it turns out that that person's abstention means there are not a majority. So if all 5 of you show up and one person abstains, and the remaining 2 split 2 and 2, well, you don't have a majority. So in that sense, the person's vote, although it wasn't a no, it really counts as a no in the sense that you don't have 3. Neither side has 3, right, to either deny or to approve. And so in that circumstance, that tie vote leads to the motion failing because there are not 3 yes votes, right? So it can sort of work into that effect in certain circumstances, just depending on how the remaining members are voting. But if the remaining 4 are voting yes, it doesn't matter,
Yeah.
right? Because that one member abstaining doesn't change that, yes, we are proceeding, because we do have
Yeah, the 4 votes.
the 4 votes, right? So it really depends how the remaining members vote when you have a person abstaining. All right, next up, executive compensation. Anytime that you, the board, are going to be voting to approve a contract or change in compensation, I'm presuming that a contract would have a change in compensation, is why I say that. Then you have to approve that at a regular meeting, not a special meeting of the board, and you have to report the salary, or if you're placing someone on a salary schedule, you have to report, this is the step and column that this person is being placed at, and the number there right now is this, right? As well as the cost of benefits orally in open session, okay? And for you, this applies not just to your CEO, right? Because the first 3 are all Jason, right? Executive director, CEO, superintendent, okay? But it also applies to department heads, right? And so for you, because you have a larger organization, you have a greater number of people that this rule applies to than a typical charter school would, because most charter schools are really small and they may only have 1 administrator, so they may not have any department heads at their school, right? So prior to board action to approve, you have to exercise due diligence by reviewing comparable compensation to ensure compliance with IRS restrictions on excess compensation for nonprofit executives. And this is a little different than the school district world because we're a nonprofit. And so as a result, we have to comply with these nonprofit rules, not just with sort of the school district world rules that apply there. This is not a big deal. It was put in place by the legislature following a debacle at a city down in Southern California where there was truly excessive compensation being provided to all of the senior city officials. And these were being approved at special meetings at random hours of the day and night. And so that's why all these particulars sort of came into place. The theory behind it is shine a bright light, force this sort of action to happen at a meeting where people are likely to be there, and hopefully it will shame people out of doing million-dollar contracts for people and stuff like this. In practice, this really hasn't been an issue in our space because most charter schools can't afford million-dollar contracts even if they wanted to, right? All right, votes of the board are public, right, during the meeting. And your board minutes should include all material motions and votes, including motions that fail. So what are the public's rights? Well, they have 6 special rights that they have anytime they're at one of your noticed meetings. They have the right to provide public testimony, and they can do that on items that are on your agenda. They also have the special privilege of being able to comment on things that are not on your agenda that relate to the charter school in some way. All of that subject to time limits that are reasonable that you set. And so most charter schools have either 2 or 3 minutes per public speaker. So that's set by you. It just has to be reasonable. They have the right to tape or broadcast your meetings. And in the old days, when I started practicing law, it looked like the camera you see on the picture, because if somebody showed up to tape or broadcast, that was a TV news crew. That's who that was. But, you know, we had this little transition when all of us got these phones with cameras on them. And during COVID, you know, when there was all the controversy of masking, no masking, vaccines, no vaccines, all of that stuff, what I saw a lot of is stakeholders, especially parents, filming on their phones and then broadcasting onto social media charter school board meetings and things that charter school board meeting members were saying at these meetings about all of those controversial topics during COVID. So I bring that up to say, just be aware now, even if there's not one of those really big cameras staring in you in the face, that doesn't mean that someone in the audience might not be taping what you're saying. And so just be thoughtful anytime you're at a board meeting, you know, that someone might record and they might broadcast you and it might end up on the evening news, even if they're just taping it on the iPhone. Well, they still have that and they can certainly send that to NBC News, right? And so just be mindful is all I'm saying, right? You can have no conditions of attendance. So what this means is you can't require someone to be a voter. You can't require them to be a resident of, you can't require them to be a parent. You can't, you know, it's just, if they're a human being and they have a pulse, they have a right to be in your meeting, and they have a right to sit through it, and they have a right to comment or exercise any of these other rights that we're talking about here. Non-discriminatory facilities. This one's pretty obvious, right? Like you can't discriminate against anyone based on a protected class in terms of admission to a facility. Where does this come up in real life? Where this comes up in real life is when a board member says, I want a teleconference from my house and I've got stairs in front. Because now that is a facility for purposes of this meeting and I need to have wheelchair access to your living room, right? So that that member of the public can participate in the meeting from your living room where you're teleconferencing from. That's where this comes up in real life. And people don't think about, you know, but it's disability access. That's where this comes up. So just be mindful of that. Members of the public have the right to copies of your agendas and other public writings. What are public writings? Those are your agenda packet for open session matters, right? Are public writings. So my presentation today is a public writing now because it's been provided to members of the board, and the minute it's been provided to members of the board, it's a public writing, and members of the public have the right to have a copy. They have a right to see what I wrote on the slide, you know, if anyone were to ask for it. You also have to provide double the time for public testimony to people who use an interpreter. So if they come to you and they're speaking Spanish and they need a translator, then they get double the time so that there is an equal opportunity for their comments and remarks to be heard. All right, now we're going to move on to some special rights of the board chair that are in SB 1100.
Don't give her more power.
Oh, she has, you're going to learn, she has all the power right now. So you're going to learn this, right? So she has the authority to remove or cause the removal of someone for disrupting the meeting. And this was a provision that got put in place during the COVID era because there was so much disruption happening at a lot of local agency public meetings. So this is not just somebody coming to say mean remarks, right? Like, I think your staff is incompetent, or I'm really unhappy with my kid's English teacher, or something like that. People have the right to say things like that, even though they may be rude, even though they may be hurtful. It's like, okay, it is what it is, you know? Your staff is working for a public agency. You've signed up to be public officials. So, you kind of brought it on yourself, taking a job in the public space, right? You just know people are going to be critical. They're going to say mean things sometimes. That's just how it is. So I'm not talking about that. But what I'm talking about is, somebody brings a megaphone and starts screaming at you so you can't conduct business. Somebody brings a boom box and starts playing it super loud so you can't conduct business, can't hear one another talk, right? That's the sort of disruption I'm talking about, okay? Or they do something that is the use of force or a true threat of force. So they take a knife out and they put it here on the podium as they're talking. Something like that would be a threat of force, right? Like as they're talking to you. That sort of behavior is unacceptable, obviously. So what are we going to do in a circumstance like that? You as chair, you're going to let them know that their conduct is disrupting the meeting and that their failure to cease that conduct is going to lead to them being removed, okay? Once you've given that warning, if they continue to persist in the behavior, you could, if you really wanted to, get up out of your chair and push them out of the room. Or you could tell staff to do so. You could tell staff to do so. But do I think that's a good idea? No. And why is that not a good idea? Because you know that the minute the person gets pushed out the door, they're going to say, my ankle got broken or whatever, excessive force was used and now I can't breathe right, whatever. Somebody's going to make some crazy claim and then we're going to have a lawsuit and it's just going to be a mess. So what are we going to do in real life? What are we going to do? Not what the law says you can do. We're going to say, we're going to recess the meeting probably. And we're going to try to just let cooler heads prevail, hopefully, and try to persuade the person to turn off the boom box. Then you're going to come back. You're going to start the meeting again. And if it happens again, what are we going to do? We're going to recess the meeting again. We're going to call the police. Because we want the police to remove the person from the meeting at your direction so that then if there's any sort of issue that occurs and their wrist gets broken or whatever allegation they may have, that lawsuit's going against the city and it's not hopefully going to involve you or members of the staff here, right?
But it is appropriate. Oh, I'm sorry.
Only half kidding, but does that include other board members?
Who are disrupting the meeting? Well, the law doesn't say, but, I suppose. I suppose. That's an interesting question.
Yeah, we had, was there other questions, Donnie? No? Oh, okay.
Okay, some more, this was another change that went into effect this year. You'll see on this slide here is that this right was expanded to include people participating in a teleconferenced meeting. And so we've had a number of issues, which I won't describe in painful detail, because you'd probably be shocked and amazed at the things that members of the public have done on Zoom calls. But, people doing things that are inappropriate. We'll just leave it at that. And they're causing disruption in some way. So we can now kick that person off the Zoom call in after, providing them the appropriate warning. Now, closed sessions, let's move on to that. No board member, staff member, or someone who's invited into closed session can disclose information from closed session without authorization of a majority of the board. Okay? So what happens if you disclose information? You're probably going to get a lawsuit from the student or parent. You're probably going to get a lawsuit from the former employee who you fired in that closed session, not even if you had good cause to fire them, just because of the confidentiality breach alone, right? So always think about the laws about process, and if you breach the process, you can get a lawsuit even if substantively you might have done the right thing for kids, right? Here are your 6 reasons you could be in closed session as a charter school board. Most of these are pretty self-explanatory. Personnel and pupil discipline are kind of similar in that the student or employee's right to privacy is why you can be in closed session. Real estate and labor negotiations have something in common. The taxpayers are looking for you to get the best deal on their behalf in some negotiation. The conference with legal counsel has a twofold. It's both to protect the attorney-client privilege, but also so you get the best deal in negotiations that may occur. And the public security exception, this one was added after 9/11 related to, potential threats to facilities that local government agencies operate. I've never seen it in practice used for that originally intended purpose, but I have seen charter schools use that one. And where it has come up has been circumstances where students have posted threats on social media against school employees or against the school generally. And you would be surprised how many of these threats are occurring, particularly post-COVID. It seems like not a week goes by that my office doesn't get a call from some charter school in California with a student having made some sort of inappropriate threat that they posted to Facebook or otherwise. This exception allows you to meet with law enforcement agencies or your legal counsel to discuss those threats and your preparedness. Right? And the idea obviously here is we don't want to telegraph to a potential perpetrator what your response plan is, right? So that's the whole point of it is you can meet with the police department, talk in closed session, have, a planning conversation to make sure, okay, do we have all the right things in place to make sure people are safe before we reopen school on Monday? Bruce.
About labor negotiations, you mean dealing with all employees of the district?
Yeah, so either people who are unionized or people who are not unionized, either one. The board can talk about negotiations in closed session, yes. Penalties and remedies, this is what can happen. You could have your board action declared null and void. You could have injunction granted against you continuing to behave in the way you were behaving. Most painfully, sometimes the prevailing plaintiff is awarded attorney's fees, and the only people who bring these actions pretty much are the really big downtown San Francisco, LA firms. So this will be a six-figure bill when you receive it, because those people bill, basically 4 times what I bill per hour. It's painful because I do these presentations and I think it would be better to be on the other side of some of these crazy things, but those people just make money hand over fist. It's gross. So potential charter revocation, just simply because any violation of law could support a charter revocation. If you're going to get one of these lawsuits before they can sue, they have to give you a notice and provide you an opportunity to cure within 30 days. So absolutely, all day long, what do I tell people to do? If it's even a gray area, just cure it within 30 days, then we don't have the lawsuit. We're not going to get the 6-figure bill. There's just no reason, if you're in a gray area even, to have a fight about it. Let's just call a board meeting. We'll post it on the agenda in the way they asked us to. We'll discuss it, we'll vote again, and we'll put the issue to bed and move on. All right. So you can see we've only covered the first topic, but I promise you the rest of the topics move much faster. So Public Records Act, okay, is to ensure that members of the public have the right to access information conducting your business. This is the process that your staff uses to process these kinds of requests when they come in the door. It's pretty straightforward. Most importantly, a request can be in any form, and it does not need to reference the Public Records Act request. And so the most common kinds of violations that I see is that a parent writes in an email, I'd like to see a copy of your policy on X. And the school doesn't treat it or think about it as a Public Records Act request. They just think, oh, this is Julie's request to me for a copy of this policy. I'll get to it when I can get to it. No, that's a Public Records Act request when that email is sent in the door. And so we owe a response. And we owe a response even if it's just a verbal request. And when do verbal requests get made all the time? To you in a boardroom during public comment. Somebody says, well, I'd like a copy of Jerry's presentation. That's a Public Records Act request, and we need to treat it as such, and we need to respond timely to that request. Okay? So what are public records? Are there any writings containing information relating to the conduct of the public's business that are prepared, owned, used, or retained by any local agency, regardless of physical form or characteristics? So super broad. So what's a writing? A writing isn't even just a writing. It includes pictures, sounds, symbols, all kinds of things, right? So what is important for you to know? The City of San Jose case is what's important for you to know. That when a city employee's writings about public business are not excluded simply because they've been sent, received, or stored in a personal account or through a personal phone. Okay, so you can use your personal phone, but if you send a text message and it's about school business on your personal phone, it is a public record, likely disclosable public record, okay? So just always be thoughtful as you're sending text messages to staff, as staff is sending text messages to you, or between and among each other, or between and among each other. Just be thoughtful. Some of those text messages may be public records that ultimately are disclosable. Same thing with emails between and among board members, from board members to staff, from staff members to each other, from staff members to the board. All of those combinations of things are likely public records unless they're excluded for some other reason, right? Some might be excluded because they're attorney-client privilege. Some might be excluded because they're personnel records. Some might be excluded because they're a student record, right? So there's examples of things that would not be public, but you always just have to be really thoughtful about this. Before you hit send, I advise you to think really hard, would I mind if this was on the front page of the Sacramento Bee? That's your test before you hit send. If you would mind, maybe better to pick up the phone and have a phone call instead. Okay, post-production, if the potential plaintiff is not happy, they think that you're hiding stuff from them, they can file suit, and if they win, they're going to get attorney's fees. Again, six-figure bill, not good. We've already talked about this, and we've covered 2 topics. So conflicts of interest. A conflict of interest arises when somebody on staff or someone on the board has some sort of private financial interest in the outcome of a contract decision or some other public decision and participates in that decision-making process. And so what does that look like? They are talking to someone about it or they are making the decision, either one. So they're attempting to influence or they are influencing. What does that mean? Well, if you murder someone, it's bad. If you attempt to murder someone, still bad, right? We're still going to punish you for the attempt because we want to discourage you from even attempting it, okay? So here are some common types of financial interest regulated by conflict laws, okay? So where do these things normally come up? When you have ownership or investment in some sort of business entity that then wants to do business with GCC, okay? I don't care that you own an apple farm in Massachusetts. That's not what we're talking about. I'm talking about a company that wants to do business with GCC, right? That's what I'm talking about. Investment in real property. Why can this matter? Well, because believe it, that when a school opens in the immediate proximity of property that you own, it may increase or decrease the value of that property depending on what is located on that property. And so we care if you are locating a school facility near real property that you own. We care about things that may impact a source of income for you. Source of income is most commonly a job, right? So if it would impact your employer, then we're concerned because we know that that puts you in a conflict because you're going to want to make your boss happy and you're going to want to make, GCC happy. And that, how do you do that if you're stuck in the middle, potentially? We care about people who give you gifts because we think those might look a lot like bribes in certain circumstances. And failing all 4 of the above, we care if it has some effect on your personal finances, even if it's not directly and specifically in one of those above 4 categories. Note also that financial interests of immediate family members, of board members, and employees typically are covered as if they were your personal interests. So, if your spouse owns stock in a company that then wants to do business with GCC, it's just the same as if you owned that stock personally and that company wanted to do business with GCC. Because we're a community property state, so any dollars that go in your spouse's pocket, it's the same as if it was into your pocket, basically, right? That's why we care. So, some new stuff. This is new. Under existing law, you've been required to fill out those Form 700s, but Assembly Bill 1286 has now expanded some disclosure requirements for all of you to talk about disclosures of arrangements for prospective employment, meaning future employment, okay? So we care now to the extent that you are going to take a job somewhere, right? And specifically where, right? We're going to be most concerned about somewhere who then wants to do business with GCC. So we care if you resign from the board and then you go take a job at a curriculum company that then is selling textbooks to GCC. That's going to be a problem, right? And so these disclosure rules are designed to ensure that you're disclosing that future prospective employment, right? That you're reporting it, that everyone here will now be aware that that's a prospective employment thing, that's some future employment you're going to have. Even if you don't work there now, we're going to assume that that's going to be a problem. And we don't want you part of any discussions. We don't want you part of any votes relating to potential contracts with that company that you are about to work for in January, okay, for example. So, Government Code Section 1090 is the most serious of these statutes because a violation of 1090 is a felony in the state of California, and you can spend time in state prison. And yes, we do have a charter school board member who was successfully prosecuted under this section of law down in Orange County. So yes, it really can happen. It really has happened. It comes up where you've got a public official, and that's any of you, meaning any board member, any staff member, right, who's in administration, who's involved in making a public contract for the sale or purchase of goods or services, and where that public official has a financial interest in the contract. So if a board member has that financial interest, the entire board is prohibited from entering into the contract, even if it's the best vendor, even if it's the best price, even if it's the only vendor within 10 miles who can provide that service, even if you went through a bidding process and this was the lowest responsive bidder. We cannot enter into that contract because a board member has a financial interest, okay? Unless an exception applies. Because you know that every member of the legislature had one buddy that they wanted to protect when they passed 1090. And so there are some incredibly weird, ticky-tacky little things like not exempting all attorneys, but only if you're an attorney at a law firm with 100 or more employees that was founded before 1964 and has entered into a contract with a local government agency for 5 or more years, this kind of nonsense. And you're just like, really? And so it's such a pain in the ass for me because every time somebody wants to ask, well, hey, is there an exception that applies? Well, now I have to go read through all of the buddy exceptions, right, to see if one of those buddy exceptions might happen to apply under this fact scenario 30 years later, right? So it's really kind of crazy. But so unless an exception applies, that is the rule, is that we're not going to enter into the contract at all. Note that making a public contract is defined very broadly. It's not just the vote that occurs here in the meeting. It's all of the earliest discussions, planning, solicitation for bids, developing the bid packet, all that sort of stuff. Why? Because we don't want you to write the bid packet so that only your spouse's company is going to be the only company with the magic equipment that you said was needed, because obviously that's going to steer the contract toward your spouse's company, right? So we care about even those early conversations, not just the final action by the board, okay? In addition to a violation of 1090 being a felony, the contract is void. So here's the super extra bad nightmare scenario, is the board member gets prosecuted and then the contract is void, so the company has to refund the money back to the charter school after it's already provided services to the charter school. So it damages the company financially, it damages the board member financially because they're having to hire a criminal defense attorney, and then at the end of it, they may end up in prison. This same sort of thing can apply to, again, to management employees who are involved in all these processes around contracting. So just be very cautious as managers or as board members. If you have any kind of financial conflict of interest, you should not participate in any discussions or votes. And what's the right thing for you to go? Go see Jason. Go see Jason. Jason, I remember from last year when Jerry did that presentation, he said, under no circumstances should I be part of anything that's a conflict of interest. And I have to tell you that I just learned that my spouse's company is sent in a response to a proposal, a request for proposal. Disclose immediately so that we can, take the appropriate steps, right? Don't wait until you see it on a board agenda. And then you're like, hey, maybe no on that. It's a little late by that point, right? Like, go immediately, disclose to Jason so Jason can make sure the right things happen. Okay, Political Reform Act. We really only look in detail at this primarily for decision-making purposes if there's an exception to 1090 that applies, right? Because this is similar but not exactly the same. It applies in the same sort of scenario where you've got a public official, they've got a financial interest, et cetera. But what it allows is that if there's an exception to 1090 and we're only looking at the Political Reform Act, if that member of the board does not participate in the discussion and does not participate in the vote, the remaining members can in fact approve that contract, okay? But again, only if an exception to 1090 applies in the first instance, then we sort of start looking here and we do this analysis, right? You're required to adopt a conflict of interest code, and in addition to it reflecting your need to fill out and file Form 700s, it will determine which staff members have to fill out and file Form 700 and which disclosure categories we expect them to fill out based on the nature of the job they perform for you. You have to file it within 30 days of assuming your board seat or your employment position, once annually by April 1st, and within 30 days of leaving your office or position if you resign your employment or your board seat. If you have a deliberate failure to file, and I underscore the word deliberate, that means intentional. You're intentionally not filing your form, okay? You can face criminal charges. I don't want people scared that like, oops, I filed it a day late, like, am I going to get thrown in jail? The reality is probably not, because they probably aren't going to be able to show you deliberately failed to file if in fact you filed it a day late, right? Like, that's probably just, you forgot. You were intending to do it, but you forgot probably. Civil or administrative action by the Fair Political Practices Commission, this means they can fine you for your failure. Common law conflicts of interest. So this comes up when there's no financial interest, but it still doesn't really pass the smell test. So this would be like a parent who sits on the charter school board and Jason shows up one day and says, I'm recommending we expel your daughter from the school. And then that board member saying, well, great, I'll be here for the closed session. And no, you won't actually be here for the closed session because we have a common law conflict of interest. Even though the expulsion of your daughter is not a financial interest of yours, it nevertheless is a conflict of interest because it creates an appearance of impropriety, right? So we still care about those kinds of things that create an appearance of impropriety as well. All right, so we're going to move on to bribery and gifts. We don't want to be in a situation, right, where you ever receive a bribe, okay? So we have to think about when people give you gifts, what's the intent of the giver and the receiver? Does that giver have business before the board? In other words, are they a proposed vendor, something like that? Is that giver attempting to influence a decision that you're trying to make? Is the receiver participating somehow in a quid pro quo? You do this for me and I'll do this for you. That's obviously problematic. Or even just could a gift have the appearance of a bribe, right? Even if it may not actually be one, just, even the appearance can send you spiraling into criminal investigations. So we're going to look a little more in detail at some of this. Penal Code Section 68 is one of the things I have to talk to you about. And all of these executive and ministerial officers, employees, and appointees of the state or a political subdivision thereof, are not supposed to be accepting bribes. And if they do, you can find yourself in prison. You also don't want to bribe other public officials. So be very careful as you have conversations with school board members or district staff about charter renewals, about charter revocations. Don't include language in any way that somebody might read the wrong way. Just be very thoughtful in how you make those communications. Some rules on gifts. You are prohibited from accepting, as a general rule, more than $590 from one source in a calendar year. The general rule also is that gifts worth more than $50 must be reported, and that's true whether somebody gives you one $50 gift or someone takes you to Taco Bell 10 times and finally trips over the $50 limit for the year. Okay? There's many exceptions before anyone panics to both of these general rules. Here are the most common ones. Special occasions like birthdays and holidays, you can get gifts from anyone other than lobbyists if the gift giving and taking is proportional. So what does that mean? Well, if I were to give Joy a package of Starbucks coffee for Christmas, if we were friends, we're not friends, I don't know Joy, really, but if we were, and I were to give her a package of Starbucks coffee, as long as she gave me something proportional in return, right, and it was roughly the same value, that would not be a problem on a special occasion, right, because it's proportional, and we're friends, right, and that's the reason for the gift. The gift is not intended as a bribe, it's just because we're friends, maybe, okay? Again, to be clear, for Joy's benefit, we're not friends and I've never given her anything, but just, theoretically. Inheritance, we know that dead people are not trying to bribe you. If they left you something, they left you money because they love you, so that's going to be fine. This incredibly long list of family members, including the spouse of your first cousin once removed, can give you gifts. As long as they're not a lobbyist, because we assume that they're giving gifts because they love you and not because they're trying to influence your decision here. If you have friends for a period of time and that gift giving and taking is proportional, it can be on any day. It doesn't have to be specifically on a birthday or a holiday, right? So if you've got some college roommate that you have exchanged gifts with for the last 40 years, there's not a problem with that as long as the gift giving and taking is roughly proportional, right? And they're not a lobbyist. Dating, we assume, as long as they're not a lobbyist, that's probably a gift because they love you. So also okay, but pro tip here, never date a lobbyist because you can't get gifts. I mean, what's even the point of dating them? I mean, really. So let's talk about returning or donating gifts. So I will tell you that the most common issue that I see with charter school board members is not that they're somehow in some crazy bribery scheme, right? The most common issue that violates the law that they do, and the same with management employees, is they receive a gift and they think, because they're such good people, they're good people at heart, and so what do they think? They think, oh, the Smith family, their mom just died. They could really use this packet of Niners tickets that the curriculum company offered. So I am going to call them back and say, yes, Miss the Smith family, I'll take those tickets and I'll give them to the Smith family. So I feel so bad their mom died, and this will cheer up the kids. You know what you did when you did that? You violated the gift limit. And you took a gift from someone who's not in one of these exceptions. And so you violated the gift law, and you violated the gift law even if you turn around and give those tickets immediately the very next second to the Smith family, you still accepted them. And because you accepted them, we have a problem on our hands. We have a legal violation on our hands. So when I see clients do things in the gift area, it's always that. It's always that they took some sort of gift with the intent to do something nice for someone else, not because they were intending to keep the gift and personally enrich themselves, right? But just know that even if you're doing that for some other person or for some other good cause, it's still prohibited.
And you're talking about a price, you said because you violated the price law. Did you say that?
$590 from...
$590.
Yeah, so if you get a 4-pack of tickets to a Niners game,
Yeah.
it's probably going to be more than the $590, right?
Yeah, but
Yeah.
if I wanted to get my administrative assistant a gift for Christmas, I can do that
Well, yes, because you're giving the gift.
I'm
You're
giving
not
the gift.
receiving the gift.
Okay, okay,
What we care about is what's regulated is you as a public official receiving gifts
okay.
where there's no exception to these gift rules, right? Because we worry that someone from some curriculum company is going to give you a gift to get in good favor, and then they're going to show up on some board agenda 3 months from now.
Uh-huh.
That's what we're worried about.
Oh, that's, okay.
Right? That's why this is all regulated, is that's the
if I-
context.
but I
You can
can
give gifts
give
to, you be as generous as you
Any
want
one
to
of
be. You be
my
as generous
staff
as you want.
people that I want to.
You can,
Without being in
again,
conflict of interest.
again, not a problem,
Since
Even the
then,
lobbyists.
not a problem up to the $590 per person.
Oh,
since my birthday, Lily can give me $590.
So, on a birthday, it could be more, right? As long as Harry's not a lobbyist, you can give him more than $590 on his birthday, yeah, so.
okay. As a board member,
As long
to
as
a
he
board
does something
member.
proportional back for you. You know? As long as he does something proportional
Oh,
back for you.
so you gotta give me something back, okay.
Yeah, so, anyway.
Okay, that's what I wanted to make
We
sure.
won't stall on this, but it illustrates the point, right? Perks of office, you can't do any of these things, right? Now, what's the thing that charter school board members, especially retired charter school board members, might do without even knowing this is a problem? The honoraria ban, number 2 on the list. Payments made for a speech given, article published, or attendance at any public or private conference, convention, meeting, social event, meal, or like gathering. Why? Because the more experience you have, the more likely you are to be invited to be the keynote speaker for XYZ conference, right? Because we want to know what your thoughts are on this issue, right? And so be mindful of this honoraria ban that is in place, okay? And if you have any circumstances like that, happy to follow up later about any particular fact patterns like that. Use of public funds. All state, federal, and local funds received by charter schools are considered public funds immediately upon receipt, and they must be used to support the educational mission. So even if you receive funds from a private source, some wonderful parent says, I want to help you out, and they write you a check for $500, and they say, please spend this money however you think best. Even in that case, those funds are converted to public funds upon receipt, and all of the restrictions on the use of public funds apply the minute they are received by you and deposited into your bank account. So for each transaction, oh yeah, Jack.
Yes, does that also apply to foundations, if we have a foundation?
No, that's a great question. So one of the most common things that charter schools do is they create a foundation and they ask people to donate there. And that's really super smart because foundations can do certain things that we're going to see in just a minute that you can't do with dollars donated directly to the charter school. So I'm going to show you a couple of slides that will illustrate that exactly. So the public scrutiny test, right? Think about, for each transaction, would the taxpaying public view the expenditure as necessary to support public education, right? And if not, then what happens? You end up as one of those headlines in the newspaper, you know, that I showed you at the beginning of the presentation. You don't want to be there. If you're questioning whether the expenditure is appropriate, it may not be. So what's the first question I always ask somebody if they call me and they go, Jerry, I'm not sure, I'm agonizing about this a little bit, I'm the CBO, what do you think? I'm like, you know, if you bothered to pick up the phone and thought it was important to call me, you probably already know the answer to this question, right? Like, you probably shouldn't do this, because if you feel that uncomfortable about it, it probably is going to look bad on the front page of the newspaper, you know? So just think about that, you know? Generally, public contracting and bidding laws do not apply to charter school expenditures, but increasingly, charter schools are now starting to get roped in, and we are seeing proposals in the legislature to rope charter schools fully in to all of the traditional public contracting laws. So, you know, we will probably end up there at some point. But right now, the most common issues that come up are food services contracts and anytime you tap into state bond funds for facilities. Those are the two areas where most charter schools end up getting sucked into bidding and contracting laws. You're not allowed to use public resources or funds for campaign activities or personal purposes. Probably none of you are planning to run for mayor, but just in case. Persons responsible for receipt, safekeeping, transfer, and disbursement of public money, which is the whole board, and Jason and your CBO at very least, are prohibited from appropriating it for personal use, keeping false accounts, or willfully obstructing lawful payments. Embezzlement, also bad. Don't do that. Gifts of public funds, okay? There's a general prohibition against lending or gifting public money in the state constitution. For charter schools in particular, there has to be a nexus between the expenditure and the mission of the public school. Expenditures should be budgeted for by the board, should further the charter school's public purpose, should be evaluated on a case-by-case basis. Purely personal items or money benefiting an individual without any consideration are not okay. So paying for a board member's vacation or the CEO's gym membership, typically not going to be okay. Here's a bunch of other things that the Fiscal Crisis Management Assistance Team has on their list of things that are not okay. And Jack, this gets directly to your question of what about a foundation? These are rules that apply to public funds, right? In other words, charter school funds that are in the charter school's accounts. Some of these things, you might say, hey, but some of these things look legit, right? Like we still think they would have a public benefit. We just can't spend public funds on it. Could we spend foundation money? And the answer is maybe yes, right? And that's the whole advantage of why you would have a foundation and why you would have people donating there directly instead. So, for example, you are prohibited from purchasing flowers for a personal gift, even if somebody's spouse died. You can't use public money for that purpose. Now, the foundation might be able to, as an example, right? You can't buy alcohol, but the foundation could if it was doing so as part of a fundraising event, for example. Holiday or other staff parties or picnics. If there's no business taking place there, no public funds could be spent for those kinds of purposes, but the foundation could, right? So those would all be examples of certain things like that. Here's a list of allowable expenses, and you will see that some of these look very similar, right? So in the case of flowers, right, it is okay if they're for a school award ceremony or a commemorative event like graduation. So that's different than an individual person being the recipient. Right? Refreshments and meals for meetings for the purpose of conducting school business. So you have a meeting of staff and you are talking about school business. That's okay to have meal for something like that. You just can't provide meals gratuitously, with no business purpose. Right? So you can see there's little distinctions here between these two sides, right? All right, we're almost all the way through. A few more slides. You want to make sure, for fairness of process, right, like this is all about just making sure that you are not discriminating at any time against anyone based on any protected class, and making sure that you're following all of the processes and policies that you have put in place as people complain to you about anything. It doesn't matter what the complaint is about. You just want to make sure those complaints are processed fairly and without discrimination. Now, where do I see charter school boards get in trouble around this? Excuse me. Where this comes up usually is parent or employee comes to charter school board member. I have a complaint about X, and tries to get you to engage in resolving that complaint or that problem. What's the right thing for you to do? The right thing for you to do is say, well, we have a policy on how complaints like this can be handled. And you should review that policy and file your complaint pursuant to that policy. Now, it might eventually reach the board level. It might, if it's not resolved below. But what you want is for the person to start at the lowest rung in that policy and try to work it out at the lowest rung. And then it moves its way up. Eventually it hits Jason. If they're still not happy, eventually they may show up here, right? And when they show up here, what am I concerned about? I don't want a situation where somebody can say, one of you had a prior conversation with only one side of a complaint, got information from only that one side, and is now a decision maker, because that's unfair. That's unfair to the other party, right, who the complaint was against. If you're going to hear something, I want you to have all the information. I want you to have all the findings of an investigation report, right? I want you to be making your decisions in an unbiased way, you know, as a matter of first impression, because you're kind of like the Supreme Court. You know, people don't get just to go show up at the Supreme Court, right? We get there only if we're not happy with the resolution of our complaint at the lower courts. We only get there on appeal, right? So, and you're like that, right? And so what I want you to say is, please go follow the policy. Please go file your complaint pursuant to the policy, and staff will work with you, you know, as you go through those steps. You may end up before us eventually, and I can't have any allegation of bias that I'm hearing information from only one side of a dispute, you know. All right, this next one got a lot more interesting last week. Doctrine of incompatible offices. So this prohibits a public official from holding two public offices simultaneously, where those offices are incompatible, either because there's divided loyalties or overlapping jurisdictions. We had a circumstance where another charter leader here in this county, Paul Kiefer, was sued, trying to remove him from the Sacramento County Board of Education because he's also the executive director of a charter school network here in the area. And the judge put out a preliminary decision, tentative ruling, last week, indicating that that the judge felt this was not an incompatible office to be serving in both of those positions at the same time. So there was a lot of speculation, like, how is this going to turn out, right? But the idea here is that if you are so excited having served on this board that you want to run for mayor or city council or something like that down the road, that's great, but you may have to resign your seat here upon being seated there, right? If it's an overlapping jurisdiction and it might create divided loyalties, right? So we'll see how that case plays out. I don't know whether there'll be an appeal. Right now it's just a tentative ruling, so it's not final yet, but we'll know soon as it final. It's a very interesting case. Nepotism. Tons and tons and tons of schools have ended up in really bad problems that have led to their closure over nepotism. And what this is it's just all about, you know, you start hiring all your family members, right? You hire family members of all the people in management and stuff. And eventually what happens is you find it's really difficult to hold people accountable for things. Because now I'm worried about, oh, that person's uncle is my boss, and well, I don't know now that I can hold that person accountable really for their poor teaching or whatever it may be. So, you know, you should have a policy on nepotism, and you should try to prevent those sorts of situations whenever possible, because they again, they're sort of the path to the dark side, right? They lead you down this path. And even if that person seems super qualified on the surface, they ultimately, it just always comes back to bite you, I find, when you're a government agency needing to comply with all of these many, many laws. You're not a private business, you know, where you're a family-owned business, you're a government agency. And so just people expect different things of you than they would expect a private company. And with that, we have completed our slides.
Oh, Oh, she told me to run Micah. Thank you so much. You have done a tremendous job. We were all very attentive to what you had to say, and there's a lot in here that we need to be very cognitive of. So, thank you. Board members, yes, Jack?
You know, I have to say, Jerry, you have convinced me. I came in really skeptical that, you know, I'd seen it all, knew it all, and been around. I learned a lot.
Yeah.
I really mean that. Your insight was really, really very good. And I just really say, I don't know how many of these presentations that you make, but you really have enlightened me. I appreciate it.
It was a pleasure being here today.
Other board members?
Thank you so much.
Any other board members, comments?
Thank you, Jerry. It was very informative. Appreciate it.
Thank you. Great. And there's a few things that I got out of this because I've seen some of these things happen, so. I used to serve on the regular school board, so, you know.
Yeah, you're school board president for 17 years? Almost.
Great. Well, maybe see your next meeting, so pleasure being here. Thanks so much.
Thank you so much. Really appreciate everything.
And then, Madam President, it's on behalf of staff, we say thank you to Jerry also for his work, and also thank you to the board for your commitment to this very transparent work that you do every day, so we do appreciate you.
And Jerry, you are invited to stay at the board meeting.
As long as you're eating.
I've got another board meeting I have to go to. Which won't surprise you. Take care.
Okay, at this point, board members, we now have a motion for adjournment from this, we don't, at this time, a motion for adjournment until our next 4:45.
I move we adjourn.
It's second. All in favor? Aye. Opposed? The ayes have it. We are now adjourned until 4:45.